Hello, this is Joshua Cunnington. I'm a managing associate at Stevenson Harwood in London, the United Kingdom, and you're listening to the IP Fridays podcast.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
I am Rolf Claessen, and my co-host Ken Suzanne and I are welcoming you to episode 166 of the IP Fridays podcast. Today's interview guest is Joshua Cunnington, who is Managing Associate at Stevenson Harwood in the UK. My co-host Ken Suzanne talks with him about an update on trademark case law in the UK, for example, the doctrine of post-sale confusion. But before we jump into the interview, I have news for you. The US Patent and Trademark Office has removed more than 52,000 fraudulent trademark applications and registrations from the register. On August 6 of 2025, the agency sanctioned a foreign filing firm that had submitted large numbers of applications using forged signatures, fake attorney identities, and manipulated specimens of use. Now, an unusual funding proposal. According to the Wall Street Journal, Commerce Secretary Lutnick is considering imposing a levy of 1% to 5% of a patent's value on patent owners. This possible patent value fee would raise additional budget funds. Details remain unclear, and the idea is already stirring controversy in the IP community. On August 4th, the USPTO's patent division issued a new guidance on patent eligibility of AI and software inventions. The Memo stresses that examiners should not hastily label software-related claims as abstract ideas. Instead, all claim elements should be evaluated together. Where eligibility is uncertain, no Section 101 rejection should be made, absent clear exclusionary grounds. In its first cost decision, the Unified Patent Court, UPC, Court of Appeal, dismissed expert client's appeal and declined to refer questions to the European Court of Justice. The judges confirmed that applications for costs must be filed no later than 1 month after judgment and saw no reason to seek guidance from the Court of Justice. It seems that the Court of Appeal generally rejects the idea that decisions of the UPC could potentially be brought before the European Court of Justice. Now let's jump into the interview with Joshua Cunnington.
Our guest today on the IP Fridays podcast is Joshua Cunnington, who is Managing Associate of Stevenson Harwood and is based in its London office. Today, we're exploring developments in IP case law in the United Kingdom. Joshua has a breadth of experience with IP litigation and also in the protection and exploitation of IP rights. He maintains a broad practice with particular sector interests in consumer goods, engineering, and technology. Joshua acts on both IP disputes and advisory matters. In his litigation practice, he has experience of taking claims to trial in the High Court and on to appeal, in addition to his work in the Company Names Tribunal and Intellectual Property Office. Joshua is a specialist in non-traditional trademark disputes, and he has particular experience litigating color and shape trademarks. Joshua is a graduate from Durham University and the University of Oxford. Welcome, Joshua, to the IP Fridays podcast.
Thank you very much, Ken. It's great to be here.
Excellent. Joshua, to start things off, are you able to set the scene and outline the main tools that brand owners have for combating lookalike or copycat products in the United Kingdom?
Absolutely. Before I drill down into the different rights, let's start about what we're talking about. So we're talking today about lookalikes or copycat products, and specifically how they can be combated by brand owners in the UK. So I'm thinking about physical products which are designed to mimic or evoke the brand owners. It might be helpful at this point to explain that historically in the UK, brand owners have found these cases to be quite difficult to win. This is because unless a trademark owner has a trademark registration for the appearance of the product, which also has a reputation, you are effectively left with relying on passing off. This, in turn, effectively requires consumers to be deceived, confused as to origin. This meant that copycats could change the name of the product effectively, but use a similar getup and not really infringe or be found to pass off.
Mm-hmm.
However, over time, more brand owners have been registering trademarks for the appearance of their products and their packaging, including non-traditional marks for shapes and colors. This allows brand owners to claim unfair advantage has been taken of their reputation, which does not require confusion, and this has really helped. So let's just touch on the various rights briefly before we get stuck into this kind of the case law specifics. So there are various rights that brand owners have, tools to their disposal, like they do in various other countries. In the UK, the primary weapon is probably trademark law, which allows for the registration of not just brand names and logos, but also the overall appearance of packaging, product shapes and colors. Take, for example, the appearance of a piece of confectionery, which I've actually had personal experience successfully registering and enforcing. A brand owner might register the shape as a trademark, the actual piece of candy. If a third party launches a product which is identical or similar to the client's registration, and this causes confusion, or if the registration has a reputation, takes unfair advantage, or dilutes or tarnishes the reputation or distinctive character, then that can infringe. The same goes for other registrations, including those for packaging, and we'll touch on that in one of the cases that we'll come on to talk about. Alongside trademarks, there's the law of passing off, which I've already mentioned, and this protects the goodwill in a brand's getup or the packaging, even if it's not registered as a trademark. So it's an unregistered tool. This is similar to unfair competition in some countries, and it's quite flexible. It allows brand owners to claim rights in basically whatever aspects of their getup they need to. But it does effectively also require confusion as well as damage, and it's a bit more involved evidentially. So it's more difficult to rely on as a brand owner against copycats.
Mm-hmm.
Then there's design rights. These are both registered and unregistered, and after Brexit, as with a lot of things have got quite complicated in the UK. But at a high level, depending on the specific right, they can protect the appearance of the whole or part of a product, including lines, contours, colors, shapes, texture, and materials. They can registered designs can offer up to 25 years of protection, whilst unregistered rights are more limited. And finally, there's copyright, as you might expect, and it has a real part to play, although it's less regularly relied upon. So you can see that in practice, there's quite a few different tools in the toolbox, as there are in lots of other jurisdictions. And I think really, though, the most commercially significant one that we see and I see in practice is trademarks, and specifically registered trademarks. And that's what we're talking about today.
Mm-hmm. Joshua, let's talk about the Thatcher's versus Aldi case. What's that all about, and why is it important?
That's a great question. It's been seen as a bit of a landmark decision in the UK. It's a Court of Appeal decision, and it involves Thatcher's, which is a cider manufacturer, producer, and Aldi, which is a discount retailer. The decision comes from earlier this year and was an appeal involving a registered trademark claim brought by Thatcher's against Aldi. Now, Thatcher's, I don't know how much your listeners will know about them, but they produce a range of different ciders, and they're quite a well-known UK producer. They have in their range a lemon cider product, and they have a registration for the appearance of the packaging itself. And hopefully we can get that in the show notes or something, but you can find it online. In the claim, they claim that Aldi had, by producing what can be described as a copycat product, had infringed the trademark. In other words, the two products themselves were argued to be similar and infringingly so, but on the basis of the registered trademark that Thatcher's owned for the actual appearance of the packaging. And the appeal focused on whether unfair advantage, i.e. riding on the coattails, had been taken by Aldi of the reputation attaching to that registration. Now, the case was complicated in some ways by the fact that the key theme to both products was the use of drawings for lemons. And if your listeners look at the images, you'll see what I mean. Lemons play a crucial part to the brand imaging and get-up. And that, as hopefully they will also see, is elusive to the flavor, i.e. a lemon cider product. However, in a very good result for brand owners, Aldi was actually held to, on appeal, to have infringed.
Now, a court finding infringement for the use of lemons for a lemon product seems like a good win for the claimant. Has the Thatcher's case made it easier for brand owners to take action against copycat products in the United Kingdom?
Now, as I say, there was a lot of excitement when this case came out. The judgment was handed down from the Court of Appeal. And at the time, there were even claims that Aldi might be forced to change their business model. They are known for being, as a discount retailer, quite aggressive in their strategies around their products and as to trying to take benchmark original brand owners' products and create their own versions. The decision itself is certainly encouraging for brand owners, but I wouldn't say it opens the floodgates. Simply using descriptive elements like lemons for lemon cider won't on its own amount to infringement. What tipped the balance, though, in this case was a combination of factors. And this came through in the evidence, which is a theme which I'll come back to as we're talking, but it's the evidence that really counts in these cases. In this case, there are numerous factors at play, but they included the fact that Thatcher's had a registration for the packaging. So it wasn't just for the logo or its name. They had a trademark registration for the packaging of the product itself. They could also prove that they had a reputation in that packaging, which is really important, and that attached to the trademark. And because of that, they could use the ground of infringement of unfair advantage, which crucially does not require confusion. All it requires is a link to be made in the mind of the consumer to the registration and for unfair advantage to be taken. The products were obviously what they were, similar, and importantly, the defendant's product was similar to the registration. There was also evidence showing Aldi's deliberate departure from its usual house style in order to get closer to Thatcher's product. And there was also evidence that Aldi intended to remind consumers of the Thatcher's product itself. And so the court found that Aldi's use of similar packaging enabled it to benefit unfairly from Thatcher's marketing investment without making its own investments, which is precisely the kind of unfair advantage that the law is designed to prevent. And so turning back to your question, I wouldn't go as far as saying that the decision makes it significantly easier for brand owners to succeed against copycats and lookalikes, but what it does do is suggest that the threshold for infringement is perhaps slightly lower than some trial judges have been applying in the UK. That said, building strong evidence is still absolutely crucial, and the factors I've talked about show that that's what really tipped the balance. And in this case in particular, it was that the evidence that Aldi had deliberately sought to create a link to Thatcher's product in the mind of the consumer. For example, there was evidence not just that Aldi had used the Thatcher's product as a benchmark, which is allowed, but they have gone further by mimicking copying elements of the trademark itself. And it is a significant decision. It's the first case for a long time in the UK, certainly at this level, where a lookalike has been found to infringe a registered trademark.
Very interesting, Joshua. Let's move on to likelihood of confusion and the Supreme Court's decision in Iconics versus Dream Pairs. What impact will this have for brand owners?
So in Iconics and Dream Pairs, which was handed down in June, and it's a UK Supreme Court decision, so that our highest court. It's a case involving a famous brand for football, i.e. soccer, and in particular football boots. And the Umbro's famous double diamond logo. And now the Umbro brand is owned by Iconics. And Iconics had sued the defendant's Dream Pairs for using what it alleged was an infringing logo for its own footwear. And again, hopefully we can show some images along with the episode. But the Dream Pairs logo was described by the trial judge as a tilted, broken, slightly rounded off square with a P-like form in the middle. But it might also be described as a broken double square at 45 degrees. And if you bear in mind that what Umbro's logo is a double diamond, hopefully you can start to see where this case is going.
Mm-hmm.
But the two trademark law issues, just to return to your question, is what's really important. And that's the case, even though the Iconic, so the Umbro brand owner, was actually ultimately unsuccessful on appeal.
Mm-hmm.
So the two issues, in a nutshell, are first whether what the court referred to as a post-sale circumstances, i.e., in this case, the real-life angle at which Dream Pairs shoes, so the defendant's shoes, would be seen when worn, i.e., if the person looking down at them, was relevant when assessing similarity between the mark and the sign. So basically, Iconics, the brand owner, was arguing that the defendant's logo looked a lot more similar when it was applied to footwear and viewed from a height. So you or I looking at each other's shoes. Meanwhile, the defendants argued that the correct comparison of the marks is actually just as they would appear as if both were on the register, i.e. straight on. So that was the first question that the court had to consider, which we'll come on to in a second, is, I think, quite relevant to lookalike cases and lookalike products. The second issue, though, concerned post-sale confusion. And this is where consumers might be confused after the point of purchase. This has been seen as relevant for some time in the UK, but its full scope has not yet been explored, or until now. In this case, the question was whether there had to be confusion at the point of a subsequent sale or transaction, or whether it's enough for a member of the public to see the sign in everyday life and confuse it for the registration.
Mm-hmm. And let's just dig further into this concept of post-sale confusion. What effect will the court's judgment in relation to the doctrine of post-sale confusion have?
So, as I say, post-sale confusion has been recognized as a relevant factor by the English courts for quite some time. In fact, one of my colleagues, Rob Jacob, worked on the first English case to recognize it in Datacard and Eagle back in 2011.
Mm-hmm.
And it's been applied a couple of times in cases since. But what this Supreme Court decision does is actually clarify whether, as defendant Dream Pairs argued, the consumer who sees the allegedly infringing mark needs to go on to a later transaction and be confused at that point later on. The argument being that the essential function of a trademark, which is to guarantee origin, must be affected in a transactional context.
Mm-hmm.
But the Supreme Court actually rejected this, and they found that there was no support for that proposition in the case law, including the EU case law, which remains binding on us in the UK, and that there's actually no principled reason to limit the doctrine in this way at all. And the impact of this decision is potentially quite significant for brand owners who are taking action against copycats, because in particular, where those products are removed from their packaging in a post-sale environment.
Mm-hmm.
It means, take for example, a pack of sweets where the sweets are removed from their packaging and put into a bowl at a party or something. It means that brand owners can rely on confusion that arises not just at the initial point of purchase, but also when the product is seen in use, say, in the example I gave with the sweets, or a football boot on the pitch, or a handbag on the street. There's no need for the consumer who sees that to go on to be confused later. It's enough for there to be evidence of the consumer mistaking the defendant's mark in the wild for the claimant's.
Mm-hmm. Now, Joshua, from your perspective as an IP attorney in the United Kingdom, do you think these judgments make it easier or harder for brand owners to prevent lookalike products, especially from retailers or competitors who closely mimic packaging or the getup?
I think these judgments provide comfort for brand owners accessing the UK courts. They do also make clear that the right evidence is still essential. On the one hand, Thatcher's Naldi demonstrates that the courts are indeed willing to intervene where a competitor's packaging goes beyond mere description and amounts to unfairly riding on the brand owner's reputation and the marketing investment that they make. And this includes cases where, on first glance, the registration in question might even have elusive or perhaps descriptive connotations. Meanwhile, the judgment in iconics and dream pairs, as we've just been discussing, to some extent increases the scope for infringement claims, in particular in the post-sale environment.
Mm-hmm.
I guess on the other hand, though, both cases show that effectively challenging copycat products relies on having strong and effective trademark portfolios still and having the best evidence, which has always been the case.
Yes, of course. Josh, let's talk about strategic advice for our listeners. Given these outcomes that we've been talking about, what strategic advice would you offer to brand owners who want to strengthen their protection for the appearance of their products in the United Kingdom?
So there are a few things I think that brand owners should be doing, and they need to be doing, to the extent they're not already. First, I think investing in registering trademarks that cover not just your brand name, but also distinctive elements of your packaging or product. Think shapes, colors, graphic designs, where possible, also register designs to protect the visual appearance of the products themselves. These are more difficult and more costly to register and can require evidence and perhaps a hearing, but it can be worth it. The example I gave earlier of registering the shape of a piece of confectionery actually led to a very quick result for my client when we needed to enforce it, which we did immediately. Secondly, building and documenting the reputation of your packaging and get-up through use is vital. Evidence of consumer recognition and marketing investment is going to be absolutely crucial when you're enforcing your rights. And documenting it is also important. There's no point in when taking action against infringers, you can't then evidence it because all that marketing spend is going to be wasted. Third, I would, when designing marketing, try and promote your get-up and not just rely on word marks. Being able to prove distinctiveness in those elements without the word marks can be really important, and consumer education is key. Fourthly, I guess I would say when monitoring the market for competitors, keep those records. Again, it's all about record keeping. And I think the Iconics decision in Iconics and Dream Pairs shows that post-sale customer confusion will be easier to rely on, and having those types of evidence will be important too. I guess lastly, if you spot a copycat, don't delay. This is a classic issue which causes claims to fail all the time in the UK, and the longer you leave a claim, the less likely you are to succeed.
That's very good advice, Joshua. This has been very informative. Thank you so much for taking the time to talk with us today on the IP Fridays podcast.
It's been an absolute pleasure. Thanks for having me.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.